The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to answer the question, what is a trust? We're going to go over some big picture things here, but we do have articles and videos, lots of them, about trusts on our website, learn-about-law.com. So if you want more detail about anything we talk about here, you can go in and dig a lot deeper. But first, let's talk about what a trust is. A trust is both a document and a legal entity that can own property separate from its creator. And the document of the trust explains how that property is going to be dealt with and the rules of the game for the trust. It's created by an individual known as a grantor or a settlor. This is the person creating the trust. And the grantor basically transfers property to the trust. Third parties can do that too. And it transfers the ownership of certain property from the grantor's name to the trust's name. So the trust now owns that property. And you might ask, like, why would someone want to do this? There's a whole bunch of different uses that trusts are used for, and we're just going to kind of rattle them off pretty quickly. But one is to distribute assets to beneficiaries after you pass away. So it often functions just like a will, and make sure that your assets get to the people that you want them to go to when you pass away. Another is management of those assets long after you pass away. So if you have minor children, you can have those assets managed for the children's benefit until they reach certain ages. A lot of people have the assets distributed to the children, a third at age 21, a third at age 25, and a third at age 30, because even once someone reaches 18, they're not necessarily of the age where their parents want to dump a huge inheritance on them. They don't want them spending that on necessarily a Lamborghini at that age. So you have the trustee managing those assets for their benefit until they reach certain ages, and that's a great function that a trust can serve. Another function of a trust is to avoid probate. When you pass away without a trust, even if you have a will, it's pretty likely if you own your home or have any significant assets at all, that your estate is going to have to go through a probate case in order for the executor of your estate to distribute assets to your beneficiaries. Probate cases are something we want to avoid because they cost a lot in legal fees. If you get the wrong attorney, anyway, they can cost 5 to 10% of the value of the estate. They take about a year before your beneficiaries can get access to your assets, and they're a big headache for your family and stressful, and there's lots of work that goes into them. So having a trust as opposed to a will as your primary estate planning vehicle allows your estate to bypass probate. Your assets can be distributed immediately without the use of an attorney to your loved ones and without the headache of a probate case. Similarly, a trust helps in avoiding guardianship proceedings or the necessity for guardianship proceedings if you become mentally incompetent. If you are certified by a doctor as mentally incompetent, the trustee of your trust can take over management of your assets for your benefit according to the terms of the trust without having to go into court to be named your guardian. We want this for all the same reasons we want to avoid probate, avoiding cost, avoiding stress, avoiding a time lag when someone needs to actually get access to manage your assets. So those are things that all those things are things that a basic revocable trust can do, and we'll talk about the difference between revocable and irrevocable. So those are things that are a common part of almost every good estate plan. Now we talk about 4 things that a trust can do that tend to be in the realm of irrevocable trusts that are more specialized. One is minimizing estate tax, so making sure that if you have a large amount of assets, there's a lot of things you can do with irrevocable trusts to make sure that those assets aren't part of your taxable estate when you pass away, and that all the assets get to your loved ones. Another is to protect assets from creditors. So if you're sued and you lose a lawsuit, you can make sure that your assets aren't available for the creditor to take or foreclose upon, and that they're preserved for the next generation of your family. Special needs planning is another big thing that we can do with something called a supplemental needs trust, and that allows you to basically, if you have a disability, allows you to receive government benefits and at the same time accumulate income and wealth in your trust without jeopardizing those government benefits. A lot of government benefits are means tested, meaning that if you make too much income and it's a small amount, or have too much in assets and that's also a small amount, you're going to reduce your government benefits. Well, supplemental needs trusts are a way around that. Long-term care and Medicaid planning is another thing we can accomplish with a trust. This one needs to be done 5 years before applying for Medicaid for long-term care, But when you apply for Medicaid, which covers the cost of a lot of long-term care, you're expected to spend down all of your assets. So basically use all of your own assets on long-term care. An irrevocable trust can allow you to keep certain assets in your family or allow them to pass to your loved ones without having to be spent down in order to be eligible for Medicaid. But again, this type of planning has to occur at least 5 years in advance of you needing the long-term care. So let's talk now about how trusts work. Those are all the different things you can do with the trust, or at least the most common. But how do trusts work? Well, every trust has a trustee and a beneficiary. The trustee is the person responsible for managing the assets of the trust for the benefit of the beneficiary according to the terms laid out in the trust. In a revocable trust, which is your standard estate planning type trust, the grantor, the creator of the trust, will usually start out as both the trustee and the beneficiary, and you'll name successor trustees who will take over after the grantor becomes mentally incompetent or passes away. The successor trustees will, the first that's willing or able to act, will take over management of the trust for the benefit of the beneficiaries. Now, if the grantor is still alive and just mentally incompetent, that'll still be the grantor. If the grantor passes away, the trust will spell out what's going to happen next, who's going to be the new beneficiaries of the trust, whether it's going to be distributed immediately or managed for a number of years, and it'll lay out all those contingencies. Let's now talk about revocable versus irrevocable trusts. A revocable trust is the type, like I said, that's used for a standard typical estate plan. This will avoid probate, help you avoid guardianship, make sure your assets are distributed the way you want, make sure you've got the right people in charge as trustees of managing those assets for the benefit of your beneficiaries. And during your lifetime, while you're mentally competent, you don't even notice the difference between owning the property in your own name versus owning the property in the trust. You have absolute control. You can change the trust at any time. You can revoke the trust at any time. The assets are really, for all intents and purposes, still absolutely yours. In an irrevocable trust, you're giving up some control over those assets, and you can't change, you can't revoke the trust generally. There are ways to undo an irrevocable trust if you get all the beneficiaries to sign off on it, but this is why an irrevocable trust is effective for estate tax planning, protecting assets from creditors. It basically it splits up the property ownership of the asset in the trust so that you have some property rights as the grantor in the property in the trust, and the beneficiaries have some property rights to the property in the trust, but it splits it up just enough that creditors can't get at it and that it may not be considered part of your estate for estate tax purposes. And there's a lot of, we've got articles and videos about irrevocable trusts and estate tax planning and all the different strategies we can use, but depending on your personal situation, there's a lot of different flavors of irrevocable trust and a lot of different ways to divide up those property rights. So that's the basics of everything you need to know. High-level overview of a trust. If you need more information, like I said, we've got a lot more detail on our website, learn-about-law.com. You can subscribe to us on YouTube, iTunes, and SoundCloud to be notified of the topics that we post, articles and videos every day. If you have any questions, please leave a comment in the comment section below this video on YouTube or below the article at learn-about-law.com. And if you need some help, we offer free consultations in both estate planning and probate law and many other areas of law. You can call us at 630-324-6666. That's 630-324-6666. We have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.